Listen to me, because this is one of the most difficult, heart-wrenching decisions you will ever have to make. But if you are sitting there, thinking about disinheriting a child or a family member, you aren't doing it because you're mean. You're doing it because something has gone wrong. Maybe it's an addiction that would turn your hard-earned legacy into a death sentence. Maybe it's decades of silence and estrangement. Or maybe you simply have a child who is so successful they don't need it, and another who will struggle for the rest of their life. Whatever the reason, you have a fear. And that fear is, can they sue me? Will my wishes actually stand when I'm not here to defend them? You are worried that your death will trigger a legal battlefield that will tear your family apart and drain every cent you worked so hard to save. You're asking yourself, what does the law actually allow? First, you need to understand the people first rule of law. In almost every state in this country, you have the absolute right to leave your money to whoever you want, with one major exception. You cannot easily disinherit a spouse. Most states have what we call an elective share, which means a spouse is legally entitled to a chunk of your estate, usually a third or a half, no matter what your will says. Unless you have a rock-solid prenuptial or postnuptial agreement where they waive that right, you cannot just leave them zero. But children? That is a different story. Except for Louisiana, which has very specific forced heirship laws for children under 24 or those with disabilities, you can disinherit an adult child. But listen to me, you cannot do it by accident. One of the biggest mistakes I see, and it is a mistake that will cost your estate thousands in legal fees, is the silent treatment. You think that by simply not mentioning your son or daughter in your will, the message is clear. It's not. In the eyes of the law, that's called an omitted child. A judge will look at that and say, oh, they just forgot to update the will. And then, that child gets a piece of your estate anyway. If you want to disinherit someone, you must be explicit. You must state their name and state clearly that you are intentionally leaving them nothing. Now, people ask me all the time, Susie, should I give them $1 so they can't say I forgot them? No! Do not do that. When you leave someone $1, they are technically a beneficiary. They have to be notified of every court date, they have to sign off on the closing of the estate, and they have the power to hold up the entire process for months or years just out of spite. Do not give them a seat at the table. You also need to understand that a will is just a piece of paper that goes to probate. Probate is public, it's expensive, and it's where disgruntled family members go to fight. If you really want to protect your wishes, you need a revocable living trust. Why? Because a trust is a private document. It doesn't go to court. It is much harder to challenge a trust than it is to challenge a will. When you set up that trust, you also want to include what we call a no contest clause. This is your insurance policy. It says that if anyone named in the trust challenges it in court and loses, they get absolutely nothing. Now, for this to work as a deterrent, you actually have to leave them something, maybe $10,000 or $50,000, enough that they think, if I fight this and lose, I lose $50,000. If you leave them zero, they have nothing to lose by suing you. You have to give them a reason to stay quiet. I want you to take an actionable takeaway right now. Go look at your beneficiary designations on your 401k, your IRAs, and your life insurance. People forget that these forms override your will. You could have a will that says, I disinherit my son, but if he is still listed as the beneficiary on your $500,000 life insurance policy, he gets that money the minute you pass away, and there is nothing your executor can do about it. This isn't just about money. It's about your power. It's about making sure that the people who loved you, cared for you, and respected your life are the ones who are taken care of when you are gone. Don't leave a mess behind because you are too afraid to have the conversation or too lazy to call a lawyer. Get your trust in order. Be clear. Be direct. And be powerful. Because when it comes to your legacy, you are the only one who gets to decide who is in and who is out.